So I want to talk to you about the challenges and chances of DORA, and I will mainly give you a practical view on DORA and its implementation in the market, mainly in the German market, but maybe we can discuss later on what your experience is. So I have been advising on the implementation of DORA since February, now on a nearly daily basis. And my clients are financial regulated entities, of course, but also IT service providers. And I've also had quite a lot of exchange with some of the large cloud providers as well. So I've seen lots of arguments on DORA and challenges of implementing it into the business cases. I'm happy to take questions. If you have questions in between, we can also have questions in between, but there will also be time in the end. So, yeah, perfect. So we had a very good introduction into the status quo already from Beatrice just now. So I have a focus on the outsourcing regime, which is at the moment really quite a challenge. And I will give you some insight from a financial entities perspective and also from an IT service provider's perspective. I will also talk a little bit about the written IT governance that is required under DORA. Yes, and we will have some takeaways in the end as well. So Beatrice already told us where we stand. So in about 5 weeks, DORA is going to apply. We got a statement from the ESAs 2 days ago, which they highlighted again that there's no transition period in DORA. It's just this 2-year of implementation period, which is very usual and very common in all regulatory acts at the moment. And 2 years are really a challenge for DORA because also DORA has been discussed since 2020. The market was not really aware of what is coming. And I would say they started end of last year to take this seriously and started their DORA projects also end of last year. But getting everything in order would be possible in 2 years' time when you had your risk management system up to date as required under PSD2, but also under the banking acts and so on. That is hardly the case. So if you were compliant with the status quo now before DORA enters into force, then everything is fine, but that's just not the reality. Also, the reality is that also for DORA projects, consultants have been hired. Hardly any new staff was hired in the financial entity, legal department, compliance department, or IT department. So people in the entity have to do DORA implementation on top of their actually daily doing. And this also are resources stretched thin at the moment. So this is also a reason why this just takes time. And the consultants, if it's true there is money spent on consultants to help with the processes, but they also only prepare those, and then you need internal staff to actually implement it and do the daily work with this. So okay, so this is some background. So the market is not yet there. Yeah. And I will also talk later on a little bit about the service providers who were mainly not aware of DORA at all until this year. I would say the exception are some of the critical third-party ICT providers, such as the large cloud providers, Microsoft, Google, Amazon. They have been aware, obviously. They have also done lobbying quite early on. and they will also be prepared by mid of January. But lots of service providers, especially smaller ones, were really hit hard. So on here I try to give you an overview. Yeah. I try to give you an overview because this is also something I'm asked in practice very, very often. What is the status of the RTSs and ITSs, and where can I find those? Here's still one mistake. This one is now, since Monday, finalized as a commission implementing regulation 2024/2956. So this has been published now. It was delayed a little bit because it was rejected in the first place by the commission. And you would think maybe there was a huge discussion point, but it wasn't actually. It was just about the line numbers. But it's finalized now. So we still have the blue ones are the ones that are still just final reports, but you can already see where this is going. So I also very often get the remark, oh, it's not finalized yet. Yes, it's true, but it is very unusual that the final reports are rejected by the commission. So it happens sometimes. Very often it's just some formal things. It's not very often some really about the content. So if you read the final reports, you have a really good idea where this is going. But as you can see, this is a lot of paper to process. And this also relates to the four main chapters under DORA. So there is the ICT risk management. This is the longest part and the most crucial part, as we also heard just from Beatrice. You have to start with the risk management of your ICT services or your ICT framework, and then going from there is a chapter on incident management and so on. And there's also the chapter of managing of the ICT third-party risk. And this is also a huge part currently in the market, which I will go into in more detail now. Let's see. Yes. So, the outsourcing, the DORA outsourcing regime does not start a completely new outsourcing setup for the financial entities, but adds to the agreements and requirements already in place. And I have tried to put some here. So there are the EBA guidelines on outsourcing arrangements, and we have additionally a cloud outsourcing guidelines, also for MIOPA. We have national law requirement for all the specific areas. So for the banking world, for the asset manager world, for payments, for investment firms. So all those areas also contain specific regulations in the specific area acts. Then we have on top of this also guidance by the NCAs. So in Germany we have MRIS. This also contains a chapter on outsourcing. We also have in Germany, as of now, a paragraph in the Banking Act that says that the NCA, so our NCA is BaFin, that BaFin can actually also directly correspond with the ITC service providers. This is something that will also come with DORA, but it is not harmonized yet. And in other member states, ICT service providers were quite interested in this, in that we already have it, but also surprised that we already have this in Germany. There was one outcome of our Wirecard scandal. Yeah, so we already have it, but it is not used so far by BaFin. yeah, that might change in the future. And I think it is good that it is harmonized so that not every member state has their own requirements. So this is particularly important for financial entities who have their business case outspun cross-border in Europe. So if you do business in several EU member states, and then you have to assess first what requirements are there in France, the Netherlands, Germany, and I don't know, Malta. It makes your life really harder. So I think in this case, DORA is really a blessing because we have a harmonized framework. And we also have harmonized guidance on the ESA's level as well, which will help to prepare for a more robust infrastructure. So having said this, you can see there's a lot going on outsourcing requirements at the moment. And now DORA comes along, and DORA actually goes way beyond what there is already there. So, and also we have guidance in Germany, in particular from BaFin, which says very specifically what you have to put into your outsourcing agreement with an IT service provider. DORA really goes beyond that. So for the financial entities, you have to amend all your agreements. And currently the outsourcing addendum of an outsourcing agreement, it's usually 2 to 3 pages. It's it's market standard, so everyone knew what to put in there. There no surprises. Also, the IT service providers were used to it, so it was not hard to negotiate. And now DORA comes along, and now it starts anew. So here I try to put in an overview of the requirements that you have to think about when managing third-party risk. I'm very often asked, oh, why is it so important that my IT service provider also complies with DORA? And I think if you look at DORA and what DORA aims to achieve, it's actually very reasonable if you outsource part of your own business and of your own processes to a third party. You are also responsible for the third parties' processes and services that they are providing to your business. And as such, I mean, you could in theory do it yourself, but if you want to be more efficient, more cost efficient, and so on, you outsource it, but then it's still part of your business setup. And if you think about the IT infrastructure of the financial market, it's just not the IT infrastructure directly in the financial regulated entities, but also the infrastructure used or provided by the third-party providers. And if you think like this, that the infrastructure is just a puzzle in the financial market, then everyone who provides a piece of the puzzle needs to ensure that the IT infrastructure is resilient and secure. In particular, if you think of cyber attacks, they can happen or they can attack at a very small but weak link going into the infrastructure. And then you can easily see that the whole infrastructure and every piece of it, also the smaller pieces, needs to be secured. So, and if we explain it to our clients like this, they actually understand it and they tend to be more willing to comply with the requirements because they see the point. So I think the overall picture is always quite important. So what you obviously also have to, once you have done your risk assessment, you obviously have to document it. And I think the documentation is at the moment quite burdensome. The documentation is always burdensome when some new regulation comes in. But here we will also see later on what has to be documented on the governance of the IT governance. And it's really a lot. So you have to assess, as also Beatrice already pointed out, the third-party service provider's risk that you are imposed to. So this has to be pre-contractual and ongoing. This is not a new requirement. If you were compliant with the EBA guidelines, it's already there. And I think most of the regulated entities in the EU and also in Germany did this, but they did it just on a high level, let's say on a high level basis. And now with DORA, high level is not enough anymore. You really have to go deeper, and you really have to sit down and try to find out what risks are involved. And this is, so you have to get people from your IT department who actually understand the IT. Then you have to have people from compliance as well. And then very often there's also someone from the legal department involved too. So you need to have several departments within the financial entity talk to each other, and they do not all speak the same language. So the IT guys usually do not speak legal, and the legal guys sometimes do not understand the IT. And then it is really helpful if you have some consultants. So mostly the market is dominated at the moment by KPMG, PwC, Deloitte, and so on. They are helping with setting up the processes, but still the financial entity staff needs to understand. It's not enough that you have some consultants that you pay good money for. You also have to understand and implement it going forward, that you can be compliant once the consultants are gone. And I have seen cases where they had DORA projects. The DORA project is finished, but it's still, in theory, they know what to do, but in practice, they don't. So it's really a challenge this time, maybe a bit more of a challenge than usually with implementing a regulation. So you also, as a financial entity, need to have a strategy on your risk management anyway, but also on your ICT third-party risk. So as you usually already have an outsourcing policy, because that is required under the EBA guidelines, you can amend your outsourcing policy and put in some more specific DORA-related risk assessment into this. There's also a delegated regulation on this, on the contractual arrangements. But there's still a lot of open questions. But that doesn't mean that you can just wait until you get guidance from the ESAs on level 3 or level 4 or from your National Competent Authority. So BaFin also gives guidance. They do webinars at the moment quite often for market participants. But still, not all your questions will be addressed, and you need to find a way to deal with this as well. Then you need to amend your agreements. I will come to this on the next slides. Your contractual agreements is also a huge task, laborious task. And then you have to have your outsourcing register in place. So you can only have your outsourcing register in place once you have your outsourcing agreements in place. And I've talked to some, I would say, medium-sized banks, and they have about 150 plus minus 20 outsourcing agreements in place. So all of those outsourcing agreements need to be adjusted as of 17th of January next year. So this is, as you can easily see, it's not going to happen. And then there are questions: what to put in this in the forms for the register? Which numbers do I have to put into the forms? Yeah. So now we have at least the final regulation on this. But still, there's also lots of questions on the line numbers. And it's not actually the requirements of the financial entities itself. They are used to regulation and on implementing regulation. We get new regulation all the time. So we know it's burdensome, it's costly, but it's fine. But tell your IT service provider located in the US that they now need a line number, or explain the difference between the line number and the U line number and so on. This just takes time. It's not complicated as such, and it's not a legal topic, but it just takes time. So, and this is also something Beatrice just said. So I get very, very often the question, what is now outsourcing for a critical or non-critical function? What is the function? When is the function critical? And then I say the same. You need to look at your business case and you need to assess when it's critical or not. And I mean, it is easy when you have the core banking system, the trading system, so the IT systems that basically are used mainly for your regulated service. That's easy. But then there are questions. What about my HR service? So I have a IT service provider who does our payroll services for us. And then I have, for the same service, I have one financial entity saying, well, we think it's critical because if we don't pay, they are not going to work anymore and it will impact my business. And then we have others that they, for this exactly same service, well, it's not critical because if this fails, we just transfer the money out of an account and we know what we have to pay everyone. So we have a backup. And that was just a simple example. And this is a question not only asked by the financial entities, but also by the ICT service providers. The ICT service providers and say, well, this is what I offer to the financial market. Can you tell me if this is supporting a critical or non-critical function? And then they say, we want to actually only serve non-critical functions because then it's not so burdensome, the whole regime. Yeah, then you can say, yes, you can try, and we can give you arguments why this should only support a non-critical function. But the decision on this lies with the financial entities. And the financial entities need to reason somehow. Doesn't really matter the outcome if it's an added service, it's not a core service. But then you look in Annex 3 of this new now regulation on the information register, and in Annex 3 there is a list on ICT services with numbers, and those numbers you can put then into the register. So that gives you an idea what ICT services could actually be. But still, as a financial entity, you have freedom to argue how you define your critical function or non-critical function. And sometimes this assessment also changes during negotiations. So which also makes negotiations just last longer. And this also makes finding a compliance strategy that fits all suppliers really hard. So usually what I see, they have 2 or 3 strategies. So one for the non-critical, one for the critical outsourcing, and then there is one for core systems where financial entities just take a bit more care and are more diligent than in cases that are not so relevant. The additional content requirement under DORA can be added either into the main agreement or in an addendum. So we usually advise that the DORA addendum makes more sense and just says in the addendum, if there's any conflict with the main agreement, the DORA addendum will prevail, and then you put all the requirements into the DORA addendum. That makes it much easier to negotiate because your main agreement can stay in place. Still not always going straightforward, but it makes things a little bit easier. And you also, if you also have business in the UK or your parent company is located in the US or in Switzerland outside of the EU, you still need to take into account that their IT services intra-group can also be impacted as well. And also which is often the case, if you are a regulated entity in a subsidiary, of your parent company, and the parent company, for cost effectiveness, provides IT services to the whole group, then also your parent company needs to comply with DORA if you have to comply with DORA as a financial entity. This also leads to a lot of discussions, and there are no exemptions for intra-group providers in DORA, which also makes sense, because then as I said previously, because then the parent company as a third-party provider also in intra-group is also part of the IT infrastructure of the financial market. So what we see currently is that nearly all financial entities are renegotiating their agreements, and they prioritize the really critical ones currently, so that they will be compliant at least in the next 2 months with their core IT services. So now let's take a view on the IT service providers. As I said, the financial entities are usually used by now to new regulation and also implementing such regulation, and they are not so nervous. It takes time, and if they have a project ongoing and they have some successes and maybe they are, I don't know, 30% done, that's all good at the moment. So there is not so much excitement on the side of the financial entities, but there's a lot of excitement on the side of the IT service providers, because they are not used to such kind of regulation. They are hit hard. They find it very onerous. You have to do a lot of explaining as a financial entity, a lot of convincing. If you are a critical IT service provider, this is an own category, and it will apply to, obviously the main cloud service providers, but there are also other service providers that will become assessed as critical in the market, and they get their own oversight regime. They are not happy and still are sometimes on denial, depends on whom you talk to. Really, are we really? Yes, you very, very likely will become a critical ICT service provider. Yeah, but so those are just the large ones. I think they can deal with it, and they are actually dealing with it. Also, it's burdensome, but they got the idea. But the also small third-party service providers need to comply of the flow down responsibilities from the financial entities, and that in negotiation is sometimes really, really hard. And then, for example, if the financial entity says, well, my business continuity management looks like this. We have discussed it, we have amended it according to DORA, and this is how it looks like. Then as a financial entity, you also need to make sure that your third-party service providers also comply with your individual BCM. And that sometimes is really hard to negotiate, because then the service providers say, well, that might be okay for you as a bank or as a payment service provider with a large business case, but we are only small ICT service provider. We cannot do this. And then they say, well, look, we also have a BCM. This is what we do. We, of course, also want that our services are continued in any event, and we have a plan and so on. And then you say, as a financial entity, then show me your plan. And then they say, well, this is a business secret. So this is how this goes, this negotiation. So then you usually also find some common room. Yeah, but it is really a challenge. So let me have a look at the time. Yeah, so I have tried to the next 3 slides. We do not have to go to every point of this, but as an overall observation, I can say that the onerous requirements that are put on, or that the IT service providers feel like they are put on them, can usually be solved with the economics. So then they just say, well, if you want more reports from us, because the reporting obligations to regulators have broadened, and also if you have an incident, you have an outsourcing chain, and the incident happens within the chain somehow, you still, as a financial entity, have to report in this short time frames that Beatrice just told us. And you need to make sure in your agreements that the IT service provider and the subs outsourcer and so on can always react within this short time frame if it's supporting a critical function. And then usually, if it cannot be avoided, like in this example, it just cannot be avoided, it has to be in the agreements, then the IT service providers usually say, okay, we can do it, but you have to pay for it. So this is usually the solution. The last way of the negotiation is about the economics, and this really usually solves the case. Yeah, let me see. There's a lot that is also not new. For example, the access and inspections and audits rights have been around for a long time. I think the most critical exit strategies have also been around for a long time. You know, the termination rights. There are now a few more termination rights. And then I've had discussions, yeah, but if I'm not a cause, if just a regulator says you need to terminate the agreement because we are not in compliance, then we are happy with this, but you still have to pay until the end of the original term. And I have seen such clauses, just that the financial entity was able to agree or finalize a negotiation they are actually willing to pay at the moment. So this might change in a few years when it's more market standard and it's more common, and the IT service providers know this all a bit better. But at the moment, that's basically what it is. And the concentration risk assessment for the dominant provider, so those who will become critical third-party providers, I think there's also a chance in this. It's not that it's not just a burden. We have seen lots of agreements where the ITC service provider just sub-outsources to a cloud service provider. And if this cloud, so Google, Amazon, Microsoft, whatever, SAP, whatever is out there, and then it's much easier for them, since then the critical third-party provider is a sub-outsourcer, but they will be compliant. They need to be compliant because they have their own supervisory regime. So this also makes things easier when somewhere in the chain there is a critical third-party provider. Also, those agreements with the critical third-party providers will not be negotiated. So they actually took care that they are compliant, and they will release their financial services addenda with DORA compliance in January. It's all in place, but there's no room for negotiation with any bank, with any exchange. It will just be the way it is, unless a supervisor will say, or the supervisory committee will say, well, this is not enough. So in here I have outlined some of the main differences of the outsourcing agreement, if it's non-critical or if it's critical. So for the non-critical part, it's all in Article 30, Para 2. And additionally, for the critical part, it's Article 30, Para 3. But you also have to take into account Article 28 and so on. This is still a bit in addition to Article 30 in DORA. But still you need service levels anyway, and you should have service levels in place if you are following the compliance of the EBA guidelines. I think this is by now standard in the whole of the EU. So, and you also need to have, as a non-critical outsourcing partner, you also need supporting the financial entity during ICT-related events. And you have to determine the costs ex ante. This is also said in DORA, which is now the time for the ICT service providers to actually say how this should go. In the requirements for the critical functions are more onerous, because the ICT incidents will be immediately more major or critical when you support a critical function, obviously. And you also need to participate as a third-party provider in TLPTs, as a threat-led penetration tests, which is a topic that we now advise to put into the agreements, but in a very broad way, because no one knows exactly how this should go at the moment. And there's no time to negotiate this in detail, how this should look like. Not even the financial entities know how this should look like at this point in time. So this is an open issue currently. And then everyone has to participate in training. So this is also a point where I think that the legislator has not thought this through, but I think the market will find a solution for this. So the ICT service provider staff should participate in a training of the financial entity on DORA compliance and ITC security. And if you are an IT service provider, let's say you have whatever 300, 400 employees, but you are serving a whole section of the market in Europe, you cannot get your staff into training, because then they would not be doing anything else than training. So I think there will probably become a market standard of DORA compliance trainings, like the AML trainings that are there in the market. So this needs to be developed, but I think the market will do this. So we also put a clause into these agreements, a vague clause, that if trainings are required, everyone will do their best. So that's it. And I think, given the time, we can skip this. Oh, sorry. We can skip this. I just put it in here. This is usually what you have in a contract in place when you look. So it's really long. It's really a long agreement. So as I said, the regulatory addendum at the moment is 2 to 3 pages, and the DORA addendum is usually 10 pages. So this is just one slide I put here. So there's a lot of internal documentation required for the financial entities under DORA. So if you go through the articles, I think this is not an exhaustive list. There were, I think, 2 or 3 more, which we did not list here. It's not all new. So in Germany, for example, BaFin gave some administrative guidance on IT, and there's a lot of the requirements that are here are already required now, but this has to be amended. It's more concrete under DORA, and it's broader than before. If you have done a good job and you have your IT risks assessed properly, then it's not such a huge task, but this is also not the reality. So the reality is everyone started a gap analysis, and then they found out that the gap analysis maybe is not a good way to do it, because it takes time, it produces costs. It would have been easier to just use the policies they have, which needed to be upgraded, and put it next to DORA, and then just go through DORA and just try to find what is missing in your policy. So some are new. for example, you need now a digital operational resilience strategy, and BaFin already says you cannot use your old policy on information security. That will not be enough. You need to do something new. So for TLTP, some entities, the large banks are already doing it. They probably also have a policy, but most market participants don't. So this is something they need to come up with. The business impact assessment is also something new. And they have to update their outsourcing policy to make it DORA compliant with regard to the ICT third-party service provider risks involved. So what we see is that the financial entities are really trying hard to become compliant with DORA soon. And what they are doing now is focusing on the agreements. They focus on the agreement so they can say, well, we have something in place. And they also have ideas how they are implementing all the requirements, the risk management requirements. But we have not seen yet a lot of really updated written policies. So I think this will come into place, whatever, in the next half year, maybe next year. Yeah, this is just something that are sometimes addressed in the projects, in the DORA projects with consultants, but also the consultants rely, same as we as lawyers, rely on the input of the financial entity, and there you still need the stuff of the financial entity to work with this. And yeah, even in large banks, I have seen, so I can only talk from mainly for the German market, but in the German market, there's really a shortage of resources, also on DORA. So, and I only have one final takeaway slide. So from my perspective, compliance in January is unlikely. So we will have partial compliance, and I think everyone is on it. So that's I think a good thing. You need to be aware that your outsourcing agreements will contain compromises on each side of the financial entity as well as the IT service provider. The financial entities sometimes think, well, they are here in the driver's seat, but they also rely on the IT service providers. So there will be compromises. There's usually an economic solution. And one other point, but I can be quite quick because we can also have this in our roundtable discussion later on. The auditors will play a crucial role in all of this before the regulators will. So in Germany, we will have once a year auditors also reviewing the compliance, and they will also review DORA compliance once a year, and they will be the first to assess DORA compliance of the financial entities. And then they will draw up a report, and this report will be submitted to the regulator, and then the regulator will take steps, actions, whatever, will become aware. Though at the moment we also discuss a lot who are the auditors, have you involved the auditors in this, and so on. And I think the chance to come back to the title of this talk, the chance here for DORA is really a more resilient IT infrastructure for the financial market, because there are a lot of near misses out there that you do not read in the papers about. But I think it is good to have a more resilient IT infrastructure. So that's it. Thank you so much for your attention.